Law Matters. Of course it does. Welcome once again. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this long-running program continues to provide legal information, relevant examples, and practical assistance to help you with the law matters because, as we say, the law matters. A better understanding of the law puts you in a better place to determine how to protect yourself, your family, and your business. As we present various topics, you may decide to handle some issues yourself. If you decide to enlist the help of a lawyer, you'll be better prepared, and so will the professionals you select. Either way, our goal always is to help you save time, money, and achieve the best possible results. As always, we want to welcome and thank Attorney David Bazar from the Bazar and Associates Law Firm in East Providence, who continues to help us with all of the topics that we cover each segment. So, plea bargaining and sentencing in the justice system. The price you pay may be an issue, whether you're guilty or not. That's our topic today. A recently published opinion piece calls the whole system into question, so we thought it would be a good time to review that. If you're innocent, should you ever plead guilty? Your immediate response may be, no, of course not. After all, that's not the truth. It's time to weigh the costs and the benefits of that. Taking a guilty plea versus choosing to go to trial. Plea mania is a very popular topic these days, so is trial penalty versus plea reward. So, David, this recent article cited that just in Rhode Island alone, there were 39,000 criminal cases in 1 year that were resolved. Only 36 went to a jury trial, meaning people decided to plead guilty, essentially convicting themselves. The state in that case means no, they don't have to present a case, they don't have to do any work. Please comment on that situation. It certainly sounds like it's fraud, potentially.
Well, a couple of things. First of all, the number of cases that went to a jury trial don't necessarily represent the number of cases that went to trial, because a lot of the criminal cases that are brought are misdemeanors that are brought in the district court, which doesn't have juries. So your first trial in a criminal case, if you do go to trial in district court, is with a waiver of a jury, so it's to the judge, and so the judge would decide that case. And so it's only a waiver of a jury in the first instance, as they call it, because if you're convicted in the district court, you have a right of appeal for a trial de novo or a brand new trial in the Superior Court, and then at that point in time would have a right to a jury trial if you wanted one.
If that's going on, at that point, is it always the case that if it's just a judge, the judge is the one who decides what the sentence will be? And if someone, how does someone then get an opportunity to say, I better plead, or should I plead?
Right. So
not guilty?
To answer the first question, which is whether the judge decides and then sentences, the answer is yes. If you waive the jury, the judge is both the trier of fact and the juror or trier of law. It's all within the judge's discretion, and once the judge makes a decision, if the judge has convicted someone, then you would go back after a pre-sentence report and that type of thing, unless you waive that, which at that point you wouldn't, for the judge to sentence you. So going back to the very beginning premise about plea bargaining and whether it's good, bad, or not, and penalties and all of those types of things. So let's just start with the opportunity to resolve your case before it has to go to trial. There are actually very valid reasons for someone to take advantage of being able to do that. If you're not guilty of whatever it is you've been tried of, I find it hard to ever advise someone, oh, well, this is just a better result, plea to it. You're admitting to something you didn't do. That's really hard to do. Now, there can be some pleas where you don't have to admit to it and you're not actually convicted and you avoid trial, so there might be some benefit to that, but you have to really know very intimately the details of what it is you're doing and how it will affect you.
And what those consequences are. So if we've talked about times when people can DIY, do it yourself. If it's a traffic situation, you could just pay the fine, or you could say, I think I'm going to talk to the judge here because I really wasn't doing whatever. no police officer is likely to say, and if you don't do this, or if you do this, we're going to tack on 16 other things that we might have found out in the past or that are in your records. So how does that play out if it's something as minor as that?
All right, so let's start with traffic violations. So those are civil violations, not criminal.
Not criminal.
For the most part. There are some that could be. But for the most part, we're talking about Rhode Island, be the traffic tribunal or the municipal court. And most cases, most people who are going before a judge in the traffic tribunal or in a municipal court can represent themselves just fine. I think, what is the enhanced penalty or the trial penalty, as you call it? Well, in most of those instances, it might be the $35 in court costs that you're attacking on versus what you might have been able to resolve otherwise. However, there are a handful of cases and charges where you really need and want to have an attorney, where there are enhanced penalties that you're looking at, loss of license, your livelihood if you have a CDL license. So there are some reasons to have an attorney in both municipal court and the traffic tribunal.
In the municipal situation, you might have the court fees, but you also might have, in some states, I believe it's points on your license or insurance hikes or whatever. So you might weigh some of those things out. Those are the easier ones, correct?
Right. Yep.
So now if we start talking about...
But just to go back to that for 1 sec.
Go ahead.
The enhancement on the penalty was what I was referring to.
Yes.
If you get convicted at trial or if you plea bargain prior to trial, it's the same conviction, so to speak, points on your license or enhanced insurance premiums or whatever it might be. So I was just referring to that as being $35 that you might spend extra to have the right to go to trial,
right
perhaps, unless it's a case where you do face some enhanced penalties.
Okay. And so if we're not in the minor issue, misdemeanors, felonies, truly criminal situations, let's talk about how being arrested and what the plea bargaining process is about. If, as we go along, you are likely to be one who could defend someone, so please present that. And also, let's talk later on about how the prosecutor might be looking at it and considering it as well.
Okay. So if you have a client who's come to you who's been charged with an offense, a misdemeanor or a felony, there's opportunities along the way for the attorney and the prosecutor, whether it's a misdemeanor and it's the town solicitor, or a felony and the attorney general in Rhode Island, district attorney probably in Massachusetts, to be able to talk at a pre-trial or some other opportunity prior to trial to say, okay, well, here's our case. This is what we see. This is what we think we can prove. And you as the defense attorney have to look and weigh and balance that and maybe have an opportunity to say, well, I don't think you can prove that charge, but if you lower the charge to something that I think is provable, you might be able to get your client a better charge and therefore a better opportunity for a lesser sentence or a lesser sentence in the particular charge that they're already facing.
I would assume that the person who's been charged, he's likely to hear, and you really should take this case, you really should plea, because we see that you also have, I don't know, a stacked deck against you, so to speak. Can a lawyer help that in any way? Mitigate it? So we see, sir, that you had priors, whatever the priors are, and I don't know the degree of severity, but do you weigh in on that if you are representing the person who needs to be defended?
Yeah, and it certainly depends on what the prior record is, but if you go to trial and you're going to be sentenced by the judge gets a pre-sentence report of all of your background, prior convictions if you have those, other types of things that you've done, both good and bad in your past. And the judge can consider all of those things in determining what your sentence should be. So that is something that can be factored in. Now, there are some cases and types of charges where you might have certain convictions before the one you have now that might give you enhanced penalties. And those are things that you have to try to deal with as a defense attorney. And that's why sometimes you might be able to convince the prosecutor, you don't have a great case, you have a case, but not for that. But you could have them amend the charge to something else where those other charges wouldn't give you an automatic increase in whatever the sentence would be. But yes, your prior conduct and all of that can come into effect, and it may be one of the reasons why you would think about some kind of plea bargain, as you call it.
And I understand that if someone hasn't retained counsel, that if they're likely, whether they go to trial or not, you are offered a defense attorney, court appointed as it is, because what you're describing certainly sounds like the average person wouldn't know how to talk to the other side and negotiate or have them rephrase or recategorize what those priors were.
In criminal cases where you're facing the possibility of incarceration, you're entitled to have an attorney appointed for you. And I think in the Miranda warnings, it even says, and an attorney will, if you can't afford an attorney, one will be appointed for you. So seriously though, you do have the opportunity to either hire your own attorney, or if you can't afford one and you're otherwise qualified for one, to have one appointed for you, which could be from the public defender's office or a court-appointed attorney.
What about the minimums that are dangled as an inducement for someone to plead guilty, saving the prosecution time, expense, and everything else? They can just pass and go to the next case. Who determines what those sentences will be, and shouldn't it always be a judge who gets to determine that? Yeah. Who does determine it?
So that is my concern with the federal system, where there are sentencing guidelines and minimum sentences and other things that are put on a sentence as they do it, almost like a point system. Well, you did this, that's going to be another point. This bumps you up to another year, and this, that, and the other thing. And you talked about the trial penalty, I think. And in the federal system, there is a penalty or a reward, depending on how you want to look at it, for either pleading before going to trial or going to trial and facing a more stiff sentence for just exercising your right to go to trial. I actually don't agree with that. I have a problem with that system. I do agree with what you said, is that a judge should be able to look at all the circumstances in determining what a fair sentence is. And if there is some incentive for pleading before trial, it shouldn't be based on a formula or guideline.
What about the entire process, David? So if the carrot is given and someone decides that they will instead go to trial, do they still have options going forward through that trial, if it's a day or longer or whatever it is, to change and plead guilty if it looks like they're probably not going to prevail, they're probably not going to win, and you as an attorney, are you likely to say, it's not looking good, let's reconsider here? Do you have those options right up until the final judgment?
Both sides can always approach the other side and talk about entering into a plea agreement. In the federal system, I'm not 100% sure what happens there, especially with where do you stand with those enhanced penalties, so to speak, for going to trial. I don't know if you, in the middle of trial stop, if you get to go back. Maybe the judge has some discretion there, but in a state system, for most part, Rhode Island, when you're in the middle of a trial and you like the way it's going, the prosecutor may come back to you and say, hey, would you consider this? Or you may go to the prosecutor if you don't like the way it's going, like some evidence went in that you didn't think should go in. And maybe you have grounds for appeal, but now does your client want to get convicted and appeal and have to go through that whole process? So you may say, well, we talked about this, would you be willing to do that or something else? So I do believe that there's always the opportunity before the jury comes back to resolve a case with the approval of the judge.
Good to know. So we've read in this article and other places from other states that have shown their sentencing guidelines. When someone pleads, the minimums are very interesting. So a sentence for fraud is 3 times as high for the defendant who opted for trial versus those who plead guilty. Burglary, sometimes 8 times higher. How arbitrary and capricious is that? How do you bring that back into line so it's actually a fair option for someone to consider?
So I don't know where those numbers come from, or if they're...
And which state or
right.
whatever.
And so from my experience, and again, here's the other side of the not having sentence guideline stories. Many times what's going to happen can be dependent on which judge you have. Some judges look at different types of things differently than other judges. So if you have a burglary, I think is charge you said, in front of one judge, that might be looked at with a stricter eye and more strenuous or stern sentencing than another judge. And the same judge may have a lesser concern about fraud than the other judge who would have been more generous on the burglary side. So if there's no guidelines, and there are always some benchmarks in guidelines, but it's when the sentencing guidelines or benchmarks are mandatory, that's where I have the problem. When there's something for the judges to be able to look at and say, this is generally what we would do, but we're allowed to deviate from that based on the circumstances and how we view this particular case and this defendant in front of us, I think that's the best system, when the judge has the ability to really look at each case individually.
I understand there are some commissions that determine sentences or sentencing guidelines. Mm-hmm. How is that generally done procedurally in various states? I mean, I'm sure that there's a variety, there always are options, but how does that process take place, Dave?
Every state will have its own different way of doing it. The federal government has its own way of doing it. So what the sentences are generally are for the courts to determine. A legislature with a governor signing it can put certain things or requirements in a statute and says if someone's convicted of this statute, this is what has to happen. Even in the traffic situation, Rhode Island, I think of the Collin Foot law, which is if you've had 3 or more convictions within an 18-month period for certain moving violations, speeding, going through stop signs, that type of thing, there are some required penalties that now get imposed, but also some that aren't. And so it's been interesting when it first came out to see how different judges read the statute, and also the difference between shall and may. So if it says if someone's convicted under this Collin Foot statute, they may have their license suspended. They shall be ordered to go to driver's retraining school, that type of thing. So how do the judges interpret that, and what do they do? Different judges have different interpretations, but shall and may actually have very unique and special interpretations under the law. And if it's may, the judge has discretion.
It sounds like in some states, judges have had their power removed in some occasions. Not always sure. That's, we're not talking about just our opinion here, but what the law is and how it is enacted. But it's good to know that there is that scope. I asked you to address the prosecutor's side. So the prosecutor approaches the person who has been charged and says, you should perhaps plead because if you plead guilty, you'll get this. How does that work for, we think we know, but how do we assume that the prosecution determines their play?
So the prosecution has to look at its case, and they have to determine how strong a case is it for us to be able to present. What's the likelihood that we could prove this case beyond reasonable doubt? What's the social implications of someone going to trial and being found not guilty in a particular case? That could be something they need to consider. Sometimes it shouldn't be. What are the political considerations? You would hope that's not factoring in a case, and a criminal case in particular. But the bottom line is really what is the likelihood of getting a conviction, and what is the cost that the state might face, or the federal government, or what, in obtaining that conviction? Because sometimes the cost of prosecution can be a factor. And if you're litigating a criminal case against a corporation, which they do, that you can charge a corporation with a criminal act, and they have almost unlimited funds, and the federal government or the state government has a lot of funds too, but is it worth spending millions and millions of dollars on that particular case to get a conviction, or might some other avenue obtain the result that the state is looking for or the federal government without having to go to trial? So those are some of the things that would factor in from the prosecution side.
Based on that article, if there are 39,000 cases, it certainly stands to reason that they would rather have it play out other than a jury trial. You mentioned the expense, the time, the people resources that it takes. That just seems phenomenal, depending, and getting worse at times, I imagine. I also saw somewhere that there's a very high percentage of those who do go to trial that are actually either dismissed or acquitted. Care to weigh in on that? I mean, it almost seems like there's a good reason that if you think you have a shred of evidence to support your own case, you'd be better off going to trial rather than automatically going to some jail time.
Right. Well, that's one of the things I was talking about at the beginning for the defendant when they look at it, to really weigh and balance. You know, I think I used the example of you are not guilty of what you're being charged with. Well, what is it that they have that suggests that there is some guilt? And why would you agree to say that you are guilty of something if whatever they have for facts and how it's applied to the law would suggest you're not? In those cases, you should go to trial. And unfortunately, sometimes people who aren't guilty get convicted. That's just something you have to weigh and balance in the back of your mind. And what is the charge? What's the seriousness of the charge? And what is your alternative? From the state's perspective, they might bring some cases where they want to obtain a certain result, but going to trial isn't necessarily the only way to obtain that result. So they bring the charge, and maybe in pre-trial, whatever they wanted that defendant to do, get counseling, do something to fix a situation, is done, and so they can dismiss the case at that point. So there's reasons for a prosecutor to dismiss a case before it goes to trial. There's reasons, of course, for someone who's not guilty to say, I want to go to trial.
It's good that you present that, because the way most of these articles, if they're written about the trial penalty, it's as if there's just a black and white, cut and dry. To see that there's a continuum there certainly sounds much more fair and reasonable. I don't know the frequency with which that happens, but when we talk about the trial penalty, it does seem, if it were just a black and white situation as it's sometimes presented, that those who choose to take advantage of their constitutional right to go to trial, they're going to be penalized with the prospect of pretty harsh sentences. And are you a gambler? If I were a gambling man, I don't know how many people want to do that gambling.
Yeah, and that's why you will see sometimes people who really have a strong case and have a strong likelihood of having a not guilty finding will actually say, well, I'll agree to this 3 months probation just so I don't have to face that trial or the cost of the trial.
Often people talk about the fact that you can indict a ham sandwich is I think the term. How do we get that? How do we prevent that from happening? When you think about if prosecutors can do that, government shouldn't want to try every case. It just takes up so much time and resources, as we say. Why wouldn't there be a reason for them to be far more selective in who they push against and who they give a pass to? I don't know. That's not the right word. But
it's prosecutorial discretion to try to look at the set of facts and what's being presented to you and determine whether or not those facts represent a violation of a statute or several statutes. So they have to have a hard time weighing and balancing what is going to serve the public interest the best. So the saying that you can indict a ham sandwich really comes from the fact that in Rhode Island, the Attorney General's office controls what gets presented to the grand jury for indictment. And the defendant can or choose not to participate in that process, but has no control over the process. So, but it's still the grand jury that's going to decide whether or not there's strong enough case to lead to an indictment
So that would presume that the prosecution has to do some preparations to present what seems to be a viable, worthwhile case to bring to court.
So, yeah, absolutely. And I will tell you, having defended people before, when I heard that the grand jury was investigating a client for a particular situation where I knew there were lots of people who had lots of evidence on that, I wrote to the attorney general who was presenting the case, and I said, please, in the course of your presentation, contact this person, this person, this person, this person. They all have information, and I think would be very significant in your decision as to whether or not to present the case to the grand jury in the first place, or that that type of information should be heard by the grand jury. And they did, in fact, present it, and there was no true bill, no indictment of the client because of all of the other witnesses that would have otherwise been overlooked by the Attorney General, because the police didn't bring it to their attention.
Really, certainly sounds as if there really is value, and here's a reason there's value to have a lawyer when it comes to something like this. I think at the beginning of the segment you mentioned something about no contest or nolo.
Nolo. Contender.
Explain that. I don't know if we actually explained what impact that has.
So when you are charged with a case, you can plead guilty, not guilty, or in many times when you are entering, this is Rhode Island, a plea, you usually plead nolo contendere, which means I'm not contesting the charges. For all intents and purposes, it's the same as pleading guilty. You're treated the same. There is a slight difference on certain circumstances where in a civil case, if you're asked if you were convicted of a crime and you pled nolo to it and there was no sentence of jail or anything of that nature, then you don't have to say you were convicted of a crime. So
when we were talking about the costs, sometimes financial, sometimes imprisonment, how about the cost of one's reputation? How do you advise clients when they're considering whether they plead or go to trial, when in fact once you've taken that plea, even if you weren't guilty, you just figured, let me take the lesser sentence? What's your input to that factor? Because if you are a professional person, that's going to carry with you for
Absolutely. And it depends on the circumstances and the charge and all of that. So I think the former governor of New York may have been charged, and information, that's how it's either by an indictment or in this case a criminal information filed with the court. And so this criminal charge is being brought against him. So I think it's one of those situations, it's a misdemeanor. How will he deal with that? How will that impact his reputation? If he is found not guilty, if he decides to go to trial and is found not guilty, will his reputation still be intact, or will it already been impugned, so to speak, by the fact that he was just charged? Those are all interesting questions, and that's part of the information that you need to think about in determining what you're going to do with a charge that's been brought against you.
That's a good point. Thank you for staying tuned to Law Matters as we present these topics. We hope it's helpful to you. So stay tuned to Law Matters. It matters to you.